Hello and welcome. I'm John Miller, founding attorney with Rock Solid Law. Every Thursday, we are doing a continuing series of short discussions regarding estate planning concepts. If you missed any of them, please feel free to go to Rock Solid Law /videos on our website, and all of the ones that we've done are there, so you can catch up a little bit. Hope you're all doing well, socially distancing during this unusual period of time. I'd just like to let you know that we at Rock Solid Law are open for business. We've remained open throughout. We allowed our employees the choice of working in the office or home. Almost everyone worked remotely for a significant period of time. And almost all of our team are back in the office, having asked if it would be okay if they come back now. We're still being very careful. We are seeing clients in the conference room, which we are cleaning at all times and taking all the precautions to keep everybody healthy. Let me see, a small adjustment. I just noticed I was cutting off my son's head. So you see some of the things that are on my credenza. Way up top in the middle, you'll see a little statue. That's Themis. She's the goddess of justice from Greek mythology. Behind her, you'll see a little top of an urn. I'm going to talk about that urn at the end of this presentation because there's a little foreshadowing to next week's discussion. How about that for keeping your interest? Okay, power of attorney is what we're here to talk about today. And our exact subject is whether it dies with you or lives on past your lifetime. The reason I think this is of interest is, most of you know, I practiced 35 years, and I have people often come to me and say, so-and-so passed away, but I have their power of attorney. What do we do? And what we do is we sit and talk. So there are all sorts of powers of attorney out there, all right? But today we're going to focus primarily on the one that is part of your estate planning. And I must say, being the good lawyer that I hope I am and to be, that this is a discussion for educational purposes. I'm by no means giving legal advice this morning. I'm an attorney who is licensed to practice in Florida and before the Supreme Court of the United States. So my knowledge is primarily limited to Florida. Although as a business lawyer, of course, I do a lot of interstate practice as well. But we pretty much keep our estate planning practice in Florida, even though I'm a member of a national team that provides services all over the country. And I'm so pleased to have access to some of the greatest minds in estate planning, really in the world, but certainly in the United States of America. And that is a privilege. So the durable power of attorney, there are many, many types. An example of one that we are not talking about today is a specific power of attorney that gives a person the ability to do something or to act as your proxy for a specific purpose. One that I see in my practice, since I have a real estate closing practice, often is a specific power of attorney allowing someone to sign your documents for you in the transfer of real estate or in borrowing a mortgage loan. Often that's the spouse, many times members of our military, and thank all of you who have served for your service, need a spouse to come in and do the signing. It is onerous, it is time consuming, but it's the right way to do it. So we do a specific power of attorney for those. Even in the realm of estate planning, the healthcare surrogate document, the person who takes care of you when you need to be hospitalized and can't answer your medical questions for yourself, is also technically a power of attorney. The power of attorney that we're going to talk about mostly today is the durable power of attorney, or sometimes called the durable family power of attorney. Why family? It's typically a member of your family that steps into this capacity. And essentially, this would allow someone else to do all the things you were unable to do for you. So let's examine that sentence. We're looking not at the medical treatment side of your future life, but at the handling of the business of your future life. Essentially taking care of all of those things that you do day in and day out that maybe you suddenly are not able to do. It could be the result of an injury, an illness, some sort of incapacity. And then, of course, ultimately, it could be if you were to develop a long-term incapacity, as we're seeing in dementia cases and things like that. So we're trying to think of the person in your life, and a backup if possible, who would be most likely to take care of your day in and day out matters, your checkbook, calling your insurance agent, dealing with your bank, paying your mortgage, all of those sorts of things that you do every day. If one day you were suddenly unable to do so, who would you choose to do that? So this is the person that you probably want to designate in your durable family power of attorney. Now, the person whom you designate is now known as your attorney in fact. Another confusing estate planning term, right? Those of you that are with me for the living will section know what I'm talking about. An attorney in fact is not the same thing as an attorney at law. So an attorney in fact doesn't have to be, and candidly, in my practice, usually isn't an attorney and counselor at law. But they're called your attorney in fact, and they're going to sign documents for you stating the word attorney in fact. And they are not an attorney who has been admitted. They do not have to be. They could be, but are usually not a person who has been admitted to practice before the bar, who is an attorney at law. So hope that might clear up a little confusion. Now, I need to talk a little bit Florida specific and give you a little tiny history lesson. For the majority of my practice, 2/3 of it, in Florida, we were able to craft durable family powers of attorney that were only a few pages long because the laws of Florida allowed us to grant broad, general powers to the attorney in fact. That changed. The law of Florida also allowed for us to grant springing powers. That is, this document doesn't allow any legal effect until it springs to life at the point in time it's needed. That's called a springing power. Now, guess what? There was a lot of question on whether or not the person who signed the power of attorney actually was incapacitated at the time some attorneys, in fact, used their powers. And so there were legal challenges. So the legislature of Florida, and I'm sure the estate planning section of the bar, got together and thought that we needed to do away with that ability to have a document that was sort of dormant but sprung to life when needed, to take away some of these litigation issues. So the thing is, you need to understand this. If you don't get anything else that I talk about in this session, a power of attorney is effective from the moment you sign it. A power of attorney is effective in favor of your attorney in fact from the moment you sign it. That means that that person could go carry out your business at that time. Therefore, it is uber important, ultra important that you choose someone you have ultimate faith and confidence in to serve, partly so they won't take action before they're supposed to. Okay, got that one? All right, I should make you raise your hands and make sure you got it, but we'll pass on that one today. I'm seeing you nod your heads. I'm not really seeing you nod your heads. So once those changes happened, almost 10 years ago now, we had to create a document, and I say we, I mean the practitioners who do this day in and day out, which would allow the attorney, in fact, to have all of those powers which used to be generally granted. And so the durable family power of attorney document became candidly larger than almost any will I've ever drafted as far as number of pages, and bigger than a lot of trusts. So it's a big one, and it's daunting to try to read this monster. But in order to give someone the ability to do all the things you could do if you were in your right mind or maybe physical capacity, we have to have page after page after page of things that you allow them to do for you. And you're going to only initial off on those ones you want. So I do have people that read them and say, I would never have that kind of thing in my life, so I'm not going to give anybody else the power to do it. And we discuss it. And you know what? It's not my choice. It's your choice. It has to do with your values, what kind of investment you might make, what kind of investment you definitely wouldn't make. You don't want to give somebody else the power to do something that you would not have done yourself. You just want to give them all the powers to do what you would have done for yourself. So from the day you sign it, which is usually the day you sign a trust, a will, and all of the other documents that are included in your estate planning practice, although we do have people come in and just need a power of attorney, so it doesn't have to be on that day, but it usually is. Is it from the day you sign it until the day you die, it is in effect. You can rescind it. You can come in and say, no, 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 I don't like that person anymore. I don't want them in charge of my affairs. I want to name somebody else instead. We'll say, let's do it. All right. So we can change it at any time. And that happens. When does it happen? A lot like in a divorce. Sometimes family members, people change and they don't really want that person to make their decisions for them anymore. Sometimes the person that was chosen for attorney, in fact, might become incompetent themselves or even die. So we have to, from time to time, look at these as we regularly update estate planning packages. Or when a client calls and says, you know what, not happy with the decision I made, let's make a change on that. And we're only too happy to do it. So from the moment you sign it all the way up until you die, it's in effect. But it's usually not used until, it should not be used until the point in time when you are not able to handle your affairs yourself. All right, so that answers the ultimate question on the title of this Zoominar this morning. Does your power of attorney die with you? Yes. The reason I asked it that way is because I'm often asked, hey, so-and-so died, but I've got their power of attorney. Can I go ahead and sell their condo or something like that? Can I do this? Can I do that? And the answer is no, because at the moment of death, when our last breath is taken, the will takes over, right? And if there is a trust, it was in effect from before that time until after that time. So the trustee continues to act in their capacity. You know, a lot of times at death, there will be a different trustee acting in the capacity as trustee. But the power of attorney is not good anymore after we take our last breath in this realm. So I guess that would be your second big note you might want to make. So I'm going to give you some examples now. I don't want to get too deep in the weeds, but I do have a power of attorney that I regularly use and I'm going to take a look at those and just brush over some areas that you would consider. So a HIPAA authorization, which is for your medical records, is something that we do in addition to the power of attorney, but we also grant the person who has your power of attorney, we give you the option of granting the ability to get your medical records. Typically people want to do that. You let your power of attorney create and fund trusts. That way they can take care of your affairs in the best manner to protect you, except transfers and distributions from trusts. If you wanted to get money to pay your bills from your trust when you're capable of doing it yourself, of course you want to have them do that. You can allow them to amend, modify, revoke, or terminate a trust. You can allow them to make gifts the same way you made gifts when you were able to. And you can choose to continue them, or you can allow them to use their discretion to give gifts. You can do gifts for Medicaid purposes. There's some planning to take advantage of government programs involved in that. Whether or not you want them to be able to give gifts to themselves. Selves is a choice. Gifts in excess of the annual federal gift tax exclusion. Maybe you don't want to risk that tax. Maybe you want to give them the ability to do those gifts Maybe the grandchildren going to college need some money. I don't know. Oh, sometimes I amaze myself because the next one is gifts for tuition. I wish I could claim that I segued that well. Anyway, gifts for tuition is the next one. For medical expenses, you probably want that one. Methods of making gifts, it will set out. You can have a standard for that, and you can allow them to do ownership and rights of survivorship. That will be moving property around that would best suit your estate plan as needed at a time you're not able to help yourself. You can allow them to change beneficiaries if necessary. Here's one some people don't want: annuities. If you are not prone to purchase an annuity, you might not want to give them that power, but most people do. To disclaim statutory elections and disclaimers in statutory elections, you probably want that so they can take care of you. Powers of appointment mean they can appoint somebody else when they're not able to do things, and some other powers that are in with that. Preparing qualified plans, that has tax consequences. State and long-term care planning may be important. It is in many people's lives. Exercise of power in favor of attorney, in fact. So there are many, many choices to be made with this document. I tell you the important thing. If you happen to work with Rock Solid Law, you're going to see this beforehand, and we're going to go over any questions before you ever get to sitting down to sign it. But whoever works with you, you absolutely want to review these, because what's it about? Those of you that tuned in last time, it's about your values. It's not about your lawyer's value. It's not about my value. It's not about the values of any member of my team, right? We all have our own personal values and what we find to be important. So we want to express those in every estate planning document, and particularly in your power of attorney. What's important about this? I mean, you guys have heard me talk about Groucho Marx and what a sad case he became and had to sit through his own guardianship proceeding while people fought over who was going to have power over him and his estate. Well, if he had had his estate planning in place, he would have decided himself who was going to be his attorney. In fact, pursuant to his power of attorney, and who would have been in charge of taking care of him and his fortune during his life. For those of you that haven't heard me speak on that subject before, he didn't. It was awful. He went through what's called a living probate and had to watch people fight over him during his life. And of course, shortly after that, he died. And so there was a big battle over his probate all over again. It's amazing how many celebrities give we estate planning attorneys some of our best stories to tell you guys. Obviously, really important where you decide to store this document. Okay, you're going to have your original. Some people do ask their attorneys to keep them. I will, under certain circumstances. It is not my preference, because my availability shouldn't determine the usefulness of your power of attorney. But it should be stored in a place that's not easily accessible to all. You obviously need to discuss these duties with the person you choose to be your attorney, in fact, and to give them ultimate access to it so they know where it's filed, know how to get there, and that sort of thing. But you don't want these floating around out there when you're capable of doing everything for yourself. So storage is really, really important. Maybe it's in a locked file cabinet that's fireproof in your home or office with instructions on how to have it accessed when necessary. Just one idea. Not even saying it's the best one, but it's the one that I've come up with after these years as one of the best. We in my family, we have a locked fireproof safe in our home, and that's where the important documents go. Again, this is an important part of your overall estate plan. You know, a lot of times people say, I just want to do a will. Well, no, you don't. I'm sorry, it's your values, not mine, but you don't want to just do a will. You need just to, once people are on it, people procrastinate. Oh my gosh, about getting their estate plan done. Once you're on it, you need to get all your documents in order. And an important one is the durable power of attorney. So I'm going to tell you a little bit about next week. And so this would be a moment that if anybody does have questions, about durable powers of attorney, to type them into the chat bar, and I'll read the message. And if you're new to Zoom, the chat link is, let's see if I can get mine up. It's right about, whoa, come on, John, about here at the bottom of your screen if you're having me on the big screen. So that's the place where you can ask me a question now. Right now, I don't have any questions, so I want to tell you a little bit. Once again, if you look on that top shelf up there, I'll try not to zoom too fast. Oh, zoom, sorry. Move too fast. You see the plant and you see the little statue of justice? Well, between them is an urn. It's a beautiful urn, and next week, I'm going to tell you about why that urn is important to me and my life, and how it make you think of a part of your estate planning that's not typically discussed. And that is called a separate writing. A separate writing is a document which is part of your estate plan, typically attached to your will and referenced in your trust, if you have one. A separate writing is a document that you do not need a lawyer to revise, so you don't even have to come back to see your attorney when you want to change this document. A separate writing is an instrument for picking out who you want to give certain things to, and I will fill you in on the process for that, what it can and what it cannot be used for. Same time next week, 9 o'clock on Thursday. I see I'm closing in on a half an hour, and at this moment I am not seeing any questions. So I'll give you back to Lionel Richie and the Commodores, and give you just a minute or two to get those questions in if you have any. Thank you so much for joining this morning. I am John Miller, founding attorney with Rock Solid Law, and it's my pleasure to do these weekly Zoominars.